Yes, ready, go. The contention that the appellant was guilty of acquiescence was rejected by the trial court on a factual finding that the appellant was not aware of the transfer. On an examination of the recitals contained in the power of attorney, the trial court came to the conclusion that the document did not confer any power to sell the property and that therefore the appellant's sister was not entitled to alienate the property since the original alienations made in 1981 and 1982 by the appellant's sister were null and void on account of lack of express power to sell. The subsequent sale made by those allies in favor of the respondent herein was also held to be invalid. On the basis of these findings, the trial court decreed the suit as prayed for para, while reversing judgment and decree of the trial court, the High Court held Point 1 that the failure of the appellant to seek the relief of setting aside the documents of transfer and oblique or recovery of possession of the property was fatal to her case. Point 2 that though the principle behind Order 2, Rule 2, Civil Procedure Code may not be applicable to suits for partition, the appellants must be held to have had constructive notice of the alienations made by her sister in view of the section 3 of the Transfer of Property Act 1982 bracket hereinafter referred to as the Act bracket close. Point 3 that once constructive notice is attributed to the appellant, any relief for cancellation of the documents of alienation would have already become time barred by the time the power of attorney was cancelled. Point 4 that since the deed of general power of attorney filed as Exhibit A1 did not contain any express power to sell the suit property, the transferee cannot be held to have exercised reasonable care as required by the proviso to Section 41 of the Transfer of Property Act 1982 and point 5 that despite this fact the appellant was not entitled to the decree for partition in view of her failure to seek the cancellation of the alienations in spite of having constructive notice of alienations. Para, as could be seen from the judgments of the trial court and the high court, the deed of general power of attorney executed by the appellants in favor of her sister on 21/7/1971 did not specifically contain any power of sale. Therefore, the trial court as well as the high court held in no uncertain terms that the appellant's sister was not competent to sell the property to the predecessor in interest of the respondent. However, the learned counsel appearing for the respondent argued that while construing a document, all punctuation marks should be given due weightage, that the deed of power of attorney was drafted by a doyen of the bar, that clause 22 of the deed of power of attorney conferred upon the agent the power to execute and register all documents, that the power to execute a document and present the same for registration should be understood to mean the power to execute documents requiring registration in the light of section 49 of Registration Act 1908, and that therefore a bona fide purchaser like the respondent should not be made to suffer. Para, But we do not agree with the above submissions of the learned counsel. For the respondent, it remains a plain and simple fact that the deed of power of attorney executed by the appellant on 21/7 1971 in favor of her sister contained provisions empowering the agent to grant leases under clause 15 to make borrowals if and when necessary with or without a security, and to execute and if necessary register all documents in connection therewith under clause 20, and to sign in her own name documents for and on behalf of the appellant and present them for registration under clause 22. But there was no clause in the deed authorizing and empowering the agent to sell the property.